Welcome to Dorsey and Whitney's semi-annual M&A update. I'd like to introduce Brian Burke, a partner in Dorsey's Mergers and Acquisitions Group. Brian?
Thank you, Sean. Good afternoon, everyone, and welcome to the M&A update, our semi-annual look at corporate and alternative entity law developments for the M&A practitioner. My name is Brian Burke, partner here in our M&A group in Minneapolis. I'm joined today by Amelia Messa, one of our Delaware colleagues and alternative entity aficionado, as well as John Van Horn, who's also a partner in our M&A group here in Minneapolis. As is usual, we have a great program for you today with lots of developments of note. So without further ado, I will turn it over to Amelia for the latest news from the great state of Delaware.
Thank you, Brian. So we have some big news in Delaware right now. As you can see from this picture, we have some changes to our Court of Chancery. Most importantly, right there in the middle, we have a new chancellor. So after the retirement of Chancellor Bouchard, Vice Chancellor Kathleen McCormick was elevated to become our chancellor on May 6th of this year. She first joined the court as Vice Chancellor on November 1st of 2018. Prior to joining the court, she was a corporate litigation partner at the firm of Young, Conaway, Stargett & Taylor, which is a local Delaware firm. She started her career working as a staff attorney with Community Legal Aid Service Society in Delaware. She attended Harvard for undergrad and Notre Dame for law school. I would say when she became vice chancellor, she really hit the ground running, put out a lot of great and thoughtful opinions. She is incredibly well respected within the Delaware legal community, and nobody was really surprised when she was selected to become our chancellor. And very notably as well, Delaware now has its first woman chancellor. So with her elevation, we had a slot open for Vice Chancellor, and Lori Will was sworn in as our Vice Chancellor on May 26th of this year. Prior to joining the court, Vice Chancellor Will was a corporate litigation partner at Wilson Sonsini in their Wilmington, Delaware office. She previously worked as an associate at Skadden Arps, again in their Wilmington office. She also had clerked for then Vice Chancellor Leo Strine. Vice Chancellor Will received her undergrad degree from Lafayette, and she attended law school at UPenn. I have to admit that I know Lori personally. I think, and I know I'm biased, but I think she's going to be a great vice chancellor. She works incredibly hard. I would actually say she's the hardest working attorney I've ever met. She definitely has a reputation for being a bit intense. So I would say if you're going to appear before her, definitely come prepared. For some other Delaware news, just to touch briefly on the current state of the Delaware courts, which I think is pretty reflective of where we kind of are around the country right now. With COVID numbers declining, Delaware's judicial emergency ended on July 13th of this year. For the most part, we're back to normal court rules. Normal procedures now apply again. Our judicial workforce is authorized to return to 100% staffing. Mask mandates, which we previously had, have now been dropped for all fully vaccinated individuals. However, those who are not fully vaccinated or are immunocompromised must continue to wear masks. But as our Chief Justice Seitz said, for anybody else who may feel more comfortable continuing to wear a mask, you should continue to do so without hesitancy. Our courts are going to continue to use social distancing. We have plexiglass shields up throughout the courthouse facilities just to make everybody a bit safer. I think they're still doing temperature checks when you walk in the door, things like that. Our jury trials have now resumed. They are giving priority to criminal cases at this point. And a lot of our courts, especially Chancery Court, are going to continue using technology such as Zoom when appropriate for certain types of hearings. And we'll see what happens as, like the rest of the country, Delaware's COVID numbers are increasing again. So with that, I will turn it over to John.
Hey, thanks, Amelia, and thank you all for joining us. It's great to be with you today. During its most recent legislative session, the Delaware legislature passed a number of amendments to the Delaware General Corporation Law and Delaware's alternative entity statutes. Governor John Carney signed the amendments into law on June 30th, and they became effective on August 1st. The only amendment to the DGCL enacted during the 2021 legislative session was a technical amendment to Section 160C. Section 160 addresses a corporation's powers with respect to ownership, voting, and other matters related to its own stock. Prior to the amendment, Section 160C provided that shares of a Delaware corporation stock may not be voted or counted for quorum purposes if they are owned by the corporation itself or a majority-owned subsidiary corporation. Note the emphasis on the last word, corporation. As amended, Section 160C now applies regardless of whether the majority-owned subsidiary is organized as a corporation or any other form of entity. So, for example, any shares of a Delaware corporation stock held by a majority-owned subsidiary, which is organized as an LLC, may not be voted or counted for quorum purposes on any matter subject to a vote of the Delaware corporation stockholders. So not much on the DGCL. Amelia, I think there was slightly more action in the alternative entity area. I'll hand it over to you.
There was. So I think we definitely made up for it with alternative entity amendments. And just a reminder, when we're talking about alternative entities, we're talking about LLCs, limited partnerships, and general partnerships. So as I noted, we have a good amount of kind of big amendments this year. One of the biggest ones I would say is that we've added Avoid or Avoidable Act Safe Harbor. Basically, we had a couple of cases where parties went to the court and asked for equitable remedies and wanted ratification, and the court said, nope, your operating agreement says that these actions mean that things are void and we can't help you fix it. And this kind of bothered some of the LLC practitioners in town who kind of said, you know, LLCs are supposed to be treated like contracts where things can be fixed, we can ratify. So in response to this, we have new subsections to the LLC Act, Limited Partnership Act, and General Partnership Statutes. These new sections provide steps to ratify acts or transactions that would otherwise be void or voidable, and they also can waive failures to comply with provisions of an operating agreement that make certain acts and transactions void or voidable. For those of you who are familiar with Section 204 that was added to the DGCL a handful of years ago, these provisions are very similar, and they basically provide for a statutory means for ratification. We also added a new information right test. This was in response to the Murphy versus VHC Venture case, where the court refused to apply a traditionally corporate test. So our Alternative Entity Acts have now been amended to provide that traditionally corporate necessary and essential test, it applies as well by default to LLCs and partnerships. Therefore, when you have a member or a partner who is seeking certain books and records, the reason for seeking that information must now be necessary and essential to the purpose that's reasonably related to such members or partners' interest as a member or partner. So very similar to our 220 cases on the DGCL side. We also had amendments relating to delegation in conflict situations. Here again, we had another case where I think it was a general partner who was conflicted, tried to delegate management authority to an independent party, and the court said, no, that doesn't work because your conflict goes with the delegation. So in response to this case, we amended our statutes to clarify that a member, manager, or partner may delegate their management authority irrespective of whether it has a conflict of interest, and that delegatee is not deemed conflicted due to the delegator's conflict. We also amended our statutes to clarify the requirements needed to form a public benefit LLC or partnership. This includes making sure you provide for what the specific benefit is that's going to be promoted by your entity in its operating agreement. We also provided for the steps for how an existing LLC or partnership can become a statutory public benefit LLC. This year we did not have any amendments to our statutory trust statute. That statute is actually only amended every other year historically, and this was an off year. I would expect that we'll see some amendments next year, and they will most likely kind of reflect the same things that we saw this year with respect to LLCs and partnerships. So with that, I will pass you to Brian, who I believe is going to talk about Blasius. Great,
yeah, thank you, Amelia. Okay, now we turn to news out of the Delaware Supreme Court, where we saw the court issue an important ruling touching on the Blasius Doctrine. Although it is a well-known tenet of Delaware corporate law, this was the first time that the Delaware Supreme Court has even mentioned Blasius in over a decade. So before we turn to the new case, let's go back to the original Blasius decision issued a long time ago in a courtroom far, far away. The Blasius decision was authored by Chancellor Allen in 1988 and dealt with unilateral board actions that affected the stockholder franchise, most particularly the stockholders' right to vote for directors. He held that even if a board is acting in the subjective good faith that their actions are in the best interest of the corporation, in order to uphold unilateral board action taken for the primary purpose of impeding or diluting the stockholder franchise, the board must sustain the burden of proving a compelling justification. And this enhanced standard review is readily adopted by the Delaware Supreme Court and has become a foundation in Delaware law. In 2007, then Vice Chancellor Strine in the Mercier versus Intertel case attempted to recast the test as part of Unical's enhanced standard of review, with directors having to prove that 1, their actions served a legitimate corporate objective, and 2, that their actions were reasonable in relation to that objective. So a legitimate objective, reasonable relation test, just like you see in Unical, which we'll discuss later in the program today. So why did Strine try to recast the test? Well, Blasius had been triggered in a variety of scenarios, such as manipulating the board size in the face of a proxy fight, or appointing directors to fill board vacancies in the face of stockholder opposition, or even adopting bylaw amendments in the face of stockholder opposition. And whenever the court found Blasius' review was triggered, the test was outcome determinative. Nobody had ever sustained the burden of proving that there is such a thing as a compelling justification until Strine's decision in Mercier versus Intertel. The Delaware Supreme Court never took up the question of whether Blasius enhanced scrutiny is, as Strine suggested, a subset of Unical enhanced scrutiny. And so that's essentially where the law has remained for the last 15 years. And that brings us back to the case at hand, Koster versus Uip Companies, which we first discussed last year. So let me refresh you on the facts. Uip Companies was owned 50-50 by 2 founders, one of whom died and left his stock to his wife, Marion Koster. The board of the company consists of the surviving founder, Stephen Schwat, and 2 executives who did not own stock. Well, as you can imagine, the 2 50-50 shareholders deadlock, and they failed to reach a deal to buy out Marion Koster's interests, and they also deadlock on the appointment of a new board. So she sues in the Chancery Court to appoint a custodian. Schwat says, wait a second, I control the board now. So over Koster's objections, the board of UIP then votes to issue a 1/3 equity stake to one of the executive directors at a price established by an independent appraiser. After a 2-day trial, then Vice Chancellor McCormick found that the stock sale was entirely fair. Even though the board here is interested, so Stephen Schwat got the benefit of breaking the 50-50 deadlock among the shareholders, and the executive director got the benefit of issuing stock to himself. So even though the board is interested, the valuation expert they hired was sufficiently independent to support a finding of both fair dealing and fair price. Thus, it was entirely fair. And as a result, Vice Chancellor McCormick said, we don't even need to reach the question of Blasius. Because the stock sale satisfied Delaware's most onerous standard of review, entire fairness, there's no need to address an enhanced scrutiny standard like Unical or its counterpart Blasius, which she found falls somewhere between the business judgment rule and entire fairness. On appeal, however, to the Delaware Supreme Court in April, Chief Justice Hyde said, stop, not so fast. The court had no issue with her finding of entire fairness. However, they said that entire fairness did not substitute for further equitable review when Koster alleged that an interested board approved the stock sale to interfere with her voting rights and leverage as an equal stockholder. So whatever standard of review Blasius is, whether it's part of Unical or not, the court found that it's a distinct inquiry from entire fairness, and so the court remanded for the Chancery Court to try again. And if you think about it, this is actually a pretty interesting result. It would have been much easier for the Delaware Supreme Court to just say that something isn't entirely fair if it has the effect of or purpose of entrenching the board. But they didn't go that route and instead focused on keeping Blasius as a separate standard to review board's conduct in those situations. So where does that leave us? Well, this case first of all shows us that the Blasius compelling justification test lives on as its own distinct standard of review, and it's not subsumed by entire fairness. It also serves as a reminder that even if a board action is taken in good faith, the board actions that impede the stockholder franchise may run afoul of Blasius. And we also learned that it's not just impeding with the stockholder's right to vote that results in a Blasius review. The Delaware Supreme Court in dicta here seemed to say that impeding on a statutory right, such as the right to seek a custodian, would also be enough to trigger Blasius review. And finally, whether and how Blasius fits in with the Unical standard to review board actions. That was clearly left open in the court's decision in a footnote, and so is something to watch for in future cases. Okay, enough on Blasius. We now turn to an update on post-closing stockholder litigation, an area where we have seen significant developments over the past few years in the MFW and Corwin lines of cases, each of which can lead to a deferential standard of review for challenged transactions and dismissal on the pleadings. So John, I'll turn it over to you to give us the latest updates on controlling stockholder transactions and MFW line of cases.
Yeah, thanks, Brian. And returning to a galaxy not so far away, we have two straight up controlling stockholder cases to discuss today. One that relates to Delaware's standard of judicial review for transactions involving a controlling stockholder, and one that relates to the fiduciary duties owed by a controlling stockholder to the non-controlling stockholders. Before turning to those cases, let's quickly review the entire fairness doctrine. Historically, under Delaware law, a transaction between a controlling stockholder and the corporation or the corporation's non-controlling stockholders has been subject to Delaware's highest judicial review standard, as Brian mentioned, entire fairness. In a transaction subject to the entire fairness standard of review, the controller must establish that the transaction was both substantively fair, that's fair price, and procedurally fair, that's fair dealing. Remedies available to the prevailing plaintiff include injunctive relief and restitution. Conn v. Lynch established an independent negotiating structure that can shift the burden of proof I just described from the controller to the party challenging the fairness of the transaction. Under the so-called Lynch doctrine, using a special committee of disinterested directors to negotiate with the controller or conditioning the transaction on the approval by a majority of disinterested stockholders, a majority of the minority stockholder vote, shifts the burden of proof to the plaintiff. Instead of the controller having the burden of proving entire fairness, the plaintiff now must prove that the transaction did not meet the entire fairness test. So we'll pause here to look at a couple recent cases, but we'll be coming back to the Lynch doctrine and MFW cases in a few slides. Our first case involves a corporate reorganization of the publicly traded cannabis company Tilray. In the reorganization, a group of Tilray's 3 founding stockholders, which the opinion dubbed Tillionaires, exchanged their shares of Privateer Holdings, a holding company through which the founders held Tilray stock, for shares of Tilray in a merger of Privateer into a downstream subsidiary of Tilray. The transaction qualified as a tax-free reorganization and allowed the 3 Tillionaires to avoid massive capital gains tax liability while at the same time maintaining their control over Tilray. Minority stockholders challenged the reorganization, asserting that Privateer and the founders controlled Tilray and used that control to effect the reorganization transaction to obtain tax benefits without adequately compensating Tilray's minority stockholders. In a motion to dismiss, the defendants argued that the entire fairness standard should not apply. They argued that while the reorganization did confer a significant benefit to Privateer and the founders, it was not detrimental to the minority stockholders because the tax benefit utilized by Privateer and the founders was not extracted from the minority stockholders. And in any event, that same tax benefit was never available to the minority stockholders. In denying the motion to dismiss, Chancellor McCormick held that entire fairness is the appropriate standard of review and that, quote, entire fairness presumptively applies whenever a controller extracts a non-ratable or unique benefit. In addressing defendants' argument that plaintiffs had failed to adequately plead a claim that the transaction represented a detriment to the minority stockholders, the chancellor held that the power dynamics in negotiations between a controller and its controlled subsidiary render a detriment reasonably conceivable, concluding that the failure of the Tilray Special Committee to use leverage on behalf of the minority by itself constituted a detriment sufficient enough to meet the pleading standard and survive the motion to dismiss. Our second case involves a challenge brought by the creditors of a failed REIT servicing firm, RCS Capital, or RCAP, in the wake of a failed capital raising transaction process conducted by the special committee of RCAP's board. Following the submission of a proposal by private equity giant Apollo Global Management, RCAP formed an independent special committee to evaluate the transaction because of a conflict of interest posed by a relationship between Apollo and RCAP's controlling stockholder. Following the receipt of the Apollo proposal, another financing proposal was submitted by Centerbridge Partners. The Centerbridge proposal contained terms unfavorable to the controller, including the surrender of preferred equity that would have resulted in the controller no longer being a controller. After the controller advised the special committee that he would not support the Centerbridge proposal, the committee abandoned its pursuit of the transaction with Centerbridge and focused on the Apollo proposal. The Apollo transaction subsequently fell apart, and after that, RCAP fell into bankruptcy. In granting a motion for summary judgment brought by the defendants, Vice Chancellor Glasscock rejected plaintiff's argument that the controller had breached fiduciary duties owed to the non-controlling stockholders by threatening the special committee into abandoning pursuit of the Centerbridge proposal in favor of the Apollo proposal. In his ruling, the Vice Chancellor noted that the evidence supported a finding that the special committee had acted independently and that the controller had not threatened the committee's independence by simply communicating to the committee how he would vote his shares. Citing the in re Synthes case, the court noted that there is no duty for a controller to sacrifice on behalf of the company. So now back to the Lynch Doctrine. Even where the Lynch Doctrine's minority protections are employed and the burden of proof is shifted from the controller to the plaintiffs, determinations of fairness almost always involve significant questions of fact, and that makes them poor candidates to be knocked out on a motion to dismiss. As a result, even after the Conn v. Lynch decision, the Delaware court dockets remained bogged down with class action stockholder lawsuits over controlling stockholder transactions, many of which were of dubious merit and all of which sought to exploit the built-in settlement value of a case that's incapable of being dismissed at the pleading stage. So in Conn v. M&F Worldwide, better known as MFW, the Delaware Supreme Court affirmed the Court of Chancery's application of a new unified approach to controlling stockholder cases. Where the following conditions are satisfied, a transaction with a controlling stockholder will be reviewed using the business judgment rule and not the entire fairness doctrine. First, the controller must condition the transaction ab initio, that is, from the beginning, on approval of both a special committee and a majority of the minority stockholder approval. The special committee must be independent and fully empowered to evaluate the transaction. This includes the right to hire their own advisors and to reject the proposed transaction with the controller. The special committee must act with care. And finally, the majority of the minority stockholder vote must be informed and uncoerced. So we have two developments in the evolution of the MFW doctrine to report on. In a motion to dismiss case, Bertow versus Glazik, Vice Chancellor Fioravante rejected what he called a novel argument that MFW may require application of the business judgment rule in circumstances where no majority of the minority stockholder vote has been obtained. The controller transaction at issue collapsed the corporate structure of a controlled publicly traded holding company called SDI. SDI's only material asset was a controlling interest in an operating public company called Turning Point Brands. The transaction was structured as a forward triangular merger under the DGCL's short form parent subsidiary merger statute. Under the DGCL, the merger could be and was affected without a vote of Turning Point stockholders. In evaluating the transaction, Turning Point appointed an independent special committee, but obviously did not condition the transaction on a majority of the minority stockholder vote, since no stockholder vote was required. Noting that the merger represented a classic self-dealing transaction, the Chancery Court ruled that entire fairness was the appropriate standard of review. In reaching this determination, the court rejected defendants' argument that the MFW safe harbor does not require a majority of the minority stockholder vote if the stockholder vote is not statutorily required to affect the transaction. So, bottom line, no shortcuts to MFW. If you want the business judgment rule to apply to your controller transaction, both a special committee structure and a majority of the minority vote will be needed. The second case affirmed the availability of the MFW safe harbor in spite of an argument by stockholder plaintiffs that MFW should not apply because a special committee was not truly independent of the controller. This transaction involved the take-private sale of a public company, Voltare, to an entity affiliated with famed investor Carl Icahn. Voltare was also controlled by Icahn through several affiliated entities. As a result, Voltare employed an MFW structure in proceeding with the transaction with the Icahn affiliate, forming a special committee to negotiate with the controller and conditioning the transaction on a majority of the minority stockholder approval. In its lawsuit, plaintiffs asserted that MFW should not apply, the protections of MFW should not apply because the Voltare special committee was not sufficiently independent of the controller. The complaint noted that one of the members had past dealings with Icahn-owned businesses and was involved at the time of the transaction in the making of a documentary about Carl Icahn. Another member had served on the boards of Icahn-controlled entities in the past. In her first decision after being sworn in as Chancellor, Chancellor McCormick noted that the special committee's members' involvement in the Icahn documentary injected an unusual fact into the analysis. Now, I'll leave it to you to decide whether the Chancellor was referring to the director's involvement in the documentary itself, or the subject of the documentary. But ultimately, the court determined that the relationships cited by the plaintiffs amounted to ordinary business relationships and were insufficient to cast enough doubt on director independence, and the case was dismissed. So that's it for MFW. So Brian, you want to tell us what's new with Corwin? Brian, you're on mute.
Thanks, John. Yeah, to refresh everyone on Corwin, we'll go back and take a look at the Corwin line of cases, and there's a couple new developments to talk about here. So in Corwin, the Delaware Supreme Court held that if a merger is not subject to entire fairness standard due to a controller, the irrebuttable business judgment rule standard of review applies in post-merger damages claims where there has been fully informed, uncoerced approval by a majority of disinterested stockholders, and that's even if Unical Revlon would otherwise apply. If Corwin does apply to shift the standard of review, then waste, not just gross negligence, but waste, must be shown to overcome the irrebuttable business judgment rule, which all but guarantees dismissal on the pleadings. Even if Corwin doesn't apply, directors will still have the benefit of a 102b7 exculpation provision, which exculpates them from monetary damages for breach of the duty of care. But reminder, of course, that protection is not available to officers. So over the past 5 years, we've seen that there are limits to the Corwin doctrine. First, it only cleanses the transaction at hand. It doesn't cleanse the bad things that precede it. So for example, we saw in the Massey case that it will not exonerate corporate fiduciaries from ignoring EPA regulations, which led to a mine explosion that killed 29 miners. That was unrelated to later sale transactions, so they were still on the hook for those actions. Second, the approval must be fully informed, and this is really important. We've seen plenty of cases where there have been disclosure failures and the stockholder vote was not fully informed, and this frequently is an area of target for plaintiffs litigators. Third, Corwin doesn't apply when the stockholder approval is coerced. The stockholder cannot be forced to vote between approving the deal or having something bad happen, like having the shares delisted where they'll be left holding nothing but an illiquid asset, and they can't be forced to vote for a bad deal in order to vote for a good one. That's structural coercion. In those cases, Corwin doesn't apply. Unless, of course, this doesn't apply when the transaction is with the controlling stockholder. That's still entire fairness. That's back in the MFW world, as John just discussed. So against that backdrop, we saw two new cases that highlight the limitations of Corwin. First, in the Pattern Energy case, we saw that when a minority stockholder is contractually obligated to vote in favor of a merger as a result of a stockholder agreement, the court will not find the stockholder vote to be fully informed. So in this case, one of the stockholders had a voting agreement obligating it to follow the recommendation of the board and vote in favor of the merger. As a result, Vice Chancellor Zurn found that Corwin did not apply. Second, in the Columbia Pipeline case, we saw again that in the wake of Corwin, in addition to plaintiffs generally targeting officers who do not have the benefit of that 102b7 exculpation protection, should Corwin not apply, that one of the fact patterns plaintiffs are alleging is a fraud on the board theory of liability. So this essentially says that the primary negotiator, be it a board member or more commonly an executive, is blinded by their personal interests and perpetuates a fraud on the board by withholding information about their side deals and side discussions with the buyer from the board in order to tilt the sales process in favor of their preferred buyer. This, of course, results in Corwin not applying as the stockholder vote is not fully informed, and further results in a breach of fiduciary duty of loyalty claim against the individual. So as we watch for further developments in Corwin, I expect we'll continue to see officers subject to potential claims, as well as more fraud on the board theories of liability. All right, switching gears. Another line of cases that we have been following closely have been cases dealing with statutory appraisal actions. So over the last 5 years, we've witnessed a massive shift in how Delaware courts approach appraisal actions, driven by the Delaware Supreme Court decisions in DFC, Dell, and Verisian. Historically, courts used discounted cash flow analysis to determine fair value for purposes of appraisal. And this would lead to jackpot valuations and created a cottage industry of appraisal arbitrageurs trying to reap the windfall of a successful appraisal action. In DFC, Dell, and Verisian, however, the Delaware Supreme Court cut that off and held that deal price and pre-market value, less synergies, should normally be given great deference in determining fair value, absent clear process failures or market irregularities. Discounted cash flow and other methodologies which sometimes produce those jackpot valuations are now the exception and not the rule in Delaware. And the reaction to this has been swift, with far fewer appraisal actions in Delaware courts than there were 5 years ago. However, there still are some appraisal actions, and in the first half of 2021, we saw cases which answered 3 interesting questions dealing with appraisal. First, with this deference to deal value, should appraisal still reflect changes in value that occurred between signing and closing? Second, can parties use pre-closing dividends to shift consideration outside the ambit of the appraisal statute? And third, when recovering an appraisal award against an empty parent company, can the former shareholder recover up the chain against the new owner or down the chain against the operating subsidiaries? So 3 good questions, and John, we saw cases touching on each of those this year.
Yeah, thanks, Brian. So the first is the most straightforward of the 3 questions. The answer here is yes. In concluding an appraisal action that lasted more than 3 years, Vice Chancellor Laster confirmed the ruling in the Aruba case that fair value in an appraisal action is to be measured as of the closing of the transaction. In December 2017, Cineworld announced the execution of a definitive agreement for its acquisition of Regal Entertainment for $23 per share in cash. Following the announcement, but prior to the closing of the transaction, the 2017 Tax Cuts and Jobs Act reduced the corporate tax rate to 21% from 35%. In the Vice Chancellor's determination, the change in tax rates resulted in an increase in the value of Regal stock equal to $4.37 per share. This amount, when added to the court's determination of deal price less synergies, as Brian just discussed, the prevailing standard for determining appraisal fair value under appraisal, deal price less synergies, resulted in a fair value at closing of $23.60 per share. This 60-cent delta to the deal price represented a 2.6% premium. Now, If, like me, you're thinking that 3 years of appraisal litigation is a lot of trouble for 60 cents, remember that there still is an arbitrage play here. The appraisal plaintiffs also collected statutory interest at a quarterly compounded rate of 5% during the pendency of the litigation. So don't feel too bad for those plaintiffs. The answer to the second question is also relatively straightforward. The answer here is no. The publicly traded global real estate firm Brookfield Property Partners acquired a firm called GGP. The transaction was structured so that 98.5% of the cash consideration paid to GGP stockholders was paid in a pre-closing dividend. The balance of the consideration, which amounted to approximately 31 cents per share, was paid at closing. A group of stockholders challenged the transaction on multiple grounds, including a claim that payment of the pre-closing dividend was a violation of Delaware's appraisal rights statute. Vice Chancellor Slights rejected this argument, focusing on language contained right within the statute. Section 262H of the DGCL directs the court to value shares as if the company were a going concern exclusive of any element of value arising from the accomplishment or the expectation of the merger, and then goes on to empower the court to take into account all relevant factors. This flexibility, according to the opinion, enables a presiding judge to view the transaction, in this case, the pre-closing dividend, along with the closing payment, as a whole as part of the appraisal process. So now we get to question 3, and the answer here is stay tuned. Following the acquisition of Source HOV by Accela, a group of former Source HOV stockholders prevailed in an appraisal action and secured a large judgment from Source HOV. After Source HOV failed to pay up, the court issued a charging order against a wholly owned subsidiary. But before the plaintiff could collect, Accela implemented an intercompany funding arrangement that flowed funds from the sub directly up to Accela, bypassing Source HOV entirely. Plaintiffs then sued both Accela and the subsidiary. So we have a traditional claim for piercing the corporate veil against Accela and a reverse veil piercing claim against the sub. In ruling on the defendant's motion to dismiss, the court applied established factors in considering whether or not to pierce the corporate veil to reach Accela, concluding that the plaintiffs had made a sufficient argument on that point to survive the motion to dismiss. But what about the reverse veil piercing claim against the subsidiary? Well, this is where things get interesting. No court had yet ruled on a claim based on a reverse veil piercing theory. So in a case of first impression, Vice Chancellor Slights employed a 2-part test. The first prong is application of the alter ego test from traditional veil piercing. The second prong is a determination based primarily in equity. Is the owner using the corporate form to perpetuate fraud or injustice? After applying the newly articulated rule, the court determined that the plaintiff's claim for reverse veil piercing, like their claim for straightforward upward veil piercing, was sufficiently pled to survive the motion to dismiss. So in the movie version of this I have in my head, I imagine Tom Hanks portraying the Vice Chancellor and proclaiming from the bench as a majestic fanfare rises up in the background. Delaware embraces and will protect corporate separateness, but Delaware will not countenance the use of the corporate form as a means to facilitate fraud or injustice. As we let my imaginary soundtrack fade into the background, we'll transition to a topic we covered back in January: busted deal litigation resulting from the COVID-19 pandemic and developments in the law of material adverse effects. And Amelia, we'll hand it back over to you for that.
Thank you, John. So let's start with taking a look back at where we are with MAEs. So Material adverse change, material adverse effect clauses, even those that have been drafted broadly, have historically been always interpreted very narrowly by our Delaware courts. So to show that a MAC or an MAE should apply to a party who's trying to escape performance of a contract, they must show that that adverse change is significant, long-term, durational, and not foreseen. Until 2018, when we got the Acorn case, no Delaware court had ever actually relieved a buyer from performance of its contract based on a MAC or MAE condition. However, we kind of looked at Acorn and said, you know, the facts here, very extreme. It's probably an outlier. We probably won't see a lot more of this. Then, of course, COVID hit, and we all kind of took a closer look again at those MAE provisions. As we talked about last time, we did have the AB Stable versus MAPS case, where the court did actually allow a buyer to walk away from an asset purchase deal. That transaction involved the purchase of 15 luxury hotels. And as you can imagine, once the pandemic hit, hotels had to be shut down, people lost their jobs, really very drastic measures were taken. Notably though, the court allowed the non-performance not because of an MAE, but actually due to the failure to comply with the ordinary course covenant. Their Vice Chancellor Laster found that it wasn't an MAE because the pandemic fell within multiple contractual exceptions of being a natural disaster or calamity. And also notably, those contractual provisions didn't even say pandemic. Another big factor at play here was the fact that here our seller was really engaging in pretty awful, very fraudulent activities, which Vice Chancellor Laster described in great detail. So moving forward, we did this year have another MAE case. This one was Snow Phipps. Basically in March of 2020, so right as the pandemic had started, started brewing, we had Decopac Holdings, which is the maker of various cake decorating supplies. They entered into an SPA with Kohlberg and Company, who is our buyer here, to sell Decopac for $550 million. Our SPA contained all of the standard reps and warranties, including an MAE provision. And there was also a condition to closing that our buyer would secure debt financing. Our buyer had entered into, customary debt commitment letter with multiple lenders, so everything seemed like it was in good shape. Then COVID really hit home. We had stay-at-home orders, and just immediately following that SPA signing, people started to order less cakes, and Decopac's business did start to decline a little bit. Then in what looked like buyer's remorse, our buyer here started to kind of look for ways to get out of the transaction. They started asking their lenders for new and much more favorable terms that the lenders all rejected. Notably, the lenders did affirm that they were still committed to fund at the agreed upon terms in that debt commitment letter. The buyer also started to produce various financial reports and forecasts that had assumptions and data that really just didn't make sense. They contradicted the numbers that Decopac was putting forward because it was noteworthy that Decopac's numbers had started to rebound a bit. I know at my house, we have little kids and everybody still had birthdays and we still ordered cakes, and it seems like the rest of the country did the same. So by April, our buyer told Decopac that they were not going to be able to secure debt financing. Decopac said, well, but we're ready to close. The buyer refused, and Decopac filed a lawsuit seeking specific performance. So to break down all the claims that were brought here, first, the court found there was no MAE. They used the standard of whether there was an event that was reasonably expected to have a material adverse effect that required an adverse change in Decopac's business over a commercially reasonable time. So in determining what a commercially reasonable period is, the court looked at years, not months, and found that that immediate dip in sales was nothing more than a blip, as the court called it. The court also found that our pandemic-related MAE did fall within a contractual exception in the SPA because Decopac wasn't impacted in a way that was disproportionate to others in the same industry. In looking at the normal course claim, the court here also found Decopac had continued to operate in the normal course of its business despite the pandemic. It looked at the various actions Decopac had taken, reducing costs, drawing on an existing credit line, and found that those actions were consistent with what Decopac had always done in prior downturns of sales. Finally, the court agreed with Decopac that the buyer here had failed to use reasonable efforts when trying to secure its financing, and it had way too easily and very conveniently abandoned its efforts to secure that financing. I think the The interesting thing in this case was actually the remedy. Here, specific performance was actually granted, which isn't done very often in Delaware. And the buyer here was ordered to actually close on the deal. This was because DecoPac was able to show that all of the requirements for specific performance were there. They had a valid contract. DecoPac was ready, willing, and very able to perform. And notably, the balance of equities tipped in DecoPac's favor. The buyer here tried to, but was not able to use the lack of financing as an argument against specific performance. That's because then Vice Chancellor McCormick applied the prevention doctrine from Delaware, where a party's breach by non-performance contributes materially to the non-occurrence of a condition of one of its duties. That non-occurrence is excused. So in taking a step back and comparing this case to the AB Stable case, I think one of the main differences was the fact that the measures taken in AB Stable, because they were hotels that had to be shut down, people lost their jobs, that was much more extreme, much more drastic than a slight decline in cake sales. So there was actually a breach of the ordinary course covenant in AB Stable that wasn't here. If we're looking for similarities between the two cases, I think the biggest one was probably the fact that the party that was really acting very inappropriately, that was the party that lost. And in each case, each of our two vice chancellors spent a significant portion of their opinions discussing those bad actions at length. The big takeaway here is we definitely have a victory for deal certainty. Cases are showing that MAEs continue to be challenging and require a durationally significant change. So to touch briefly on another MAE case that we had just last month, this one actually not involving COVID, we had the Barty Diagnostics versus Hillrom case. This was Vice Chancellor Slights. He found there was no MAE under a merger agreement. So for some background, Barty Diagnostics is a company that produces a patch that detects heart arrhythmias. And in January of this year, a company called Hillrom agreed to acquire Barty. So one of the biggest income sources for Barty is a Medicare reimbursement that they get. And 2 weeks following the signing of the deal, that Medicare reimbursement rate was reduced in 2 of its major jurisdictions by approximately 86%. So a pretty significant reduction. Notably, by April, that reduction had been decreased, but it was still less than half of the historic rate that Barty had been receiving. Barty's business, however, was still doing well. Despite that reduction, its revenues were up for the first quarter of 2021. Vice Chancellor Slights here ended up finding that the effect of that reduction in the Medicare reimbursement rate was not durationally significant and therefore not an MAE. The Delaware courts have never actually set a specific time for what it means to be durationally significant. Instead, they look to the specific facts of each case. Here as well, that reimbursement reduction was also found to fit within the contractual exception of the MAE definition, because in this case, it was a change in healthcare law. The reduced rate was also not found to have a disproportionate impact on Barty as compared to the one other company that was similarly situated in the industry. And again, the court continued to look at the specific language used in the contract. So I think we can't place enough emphasis on how important that contractual language is. Finally, specific performance was again granted. This time, even better, they got an award of prejudgment interest on the deal price.
We next turn to poison pills, sometimes affectionately referred to as a shareholder rights plan. These plans have come in a variety of forms over the years. We saw a really important case here that dealt with a very aggressive pill adopted in the early throes of the pandemic, which has important considerations for every company that is considering adopting a poison pill. So first, a little history. Poison pills were first conceived back in 1982 by Marty Lipton of Wachtell as a defensive mechanism to protect against hostile takeovers. And they quickly became a popular tool to protect against the corporators of the 80s, such as T. Boone Pickens, Carl Icahn, and Ronald Perlman. Now, the way they work varies, but often a board adopts a plan that says if a potential acquirer acquires over 15 or 20% of the outstanding stock, then a rights offering is triggered whereby every other stockholder has the right to purchase additional shares at a steep discount. This effectively dilutes the acquirer's investment and forces them to negotiate with the board if they want to conduct a takeover. Since then, the Delaware Supreme Court has upheld the use of poison pills as a valid countermeasure that boards can use. When a poison pill is challenged, courts apply enhanced scrutiny as the standard of review under the two-part test articulated in the Unical decision. And that is that 1, the board must have a reasonable grounds for concluding that a threat to the corporate enterprise existed, and 2, that defensive measures must be reasonable in relation to the threat posed. Under that rubric, Delaware courts have repeatedly found pills to be valid as defensive measures against corporate takeovers or to protect a corporation's valuable net operating losses from changes of control, which would devalue them, but they will order rescission against inappropriately adopted pills. And that brings us to the recent case of Uip Companies stockholder litigation, where shareholders challenged an aggressive pill that was put in place preemptively by the Williams companies. In March of 2020, the pandemic and an oil price war caused Williams Companies stock to drop precipitously, 55%. The board was quickly concerned that their undervalued stock price could be an invitation to activist investors. They had had experience in the past with one that launched a proxy contest a few years ago and had no desire to repeat the experience. As a result, just a few days later, the board adopted an aggressive poison pill aimed at preventing an activist investor from even getting a toehold in the company. The trigger was set at 5%, much less than the typical 15 to 20% used in pills, and it contains much broader definitions than those used in the disclosure regime in Section 13D of the Exchange Act. The definition of acquiring person included persons who acquired options and other synthetic instruments. Its acting in concert definition included a wolf pack provision, which looped in investors engaged in parallel conduct, and it had a very limited passive investor exemption, which did not exempt any investors who seek to direct or cause the direction of management and policies of the company. So this pill went before Vice Chancellor McCormick, at the time Vice Chancellor, and she used the Unicalc two-part test to evaluate it. First, she looked at whether the board had reasonable grounds for concluding that a threat to the corporate enterprise existed. And she essentially found the answer to be no. Stockholder activism is not a threat. It's intertwined with the stockholder franchise, as is the ability of stockholders to pursue a short-term agenda if they like. It's not up to the board to protect stockholders from themselves. The board also advanced a theory that they wanted to protect against a stockholder rapidly accumulating shares without their knowledge. The federal disclosure regime, as you recall, only requires stockholders to disclose their position within 10 days of crossing the 10% threshold. And some scholars, including former Chief Justice Strine, have questioned whether a pill can be used to fill that gap. The stockholder is obligated to provide notice sooner in order to prevent the triggering the pill and allow them to continue to accumulate stock. Well, without addressing whether that can be a reasonable type of pill, Vice Chancellor McCormick found that in any event, this pill was far too extreme and went far beyond the notice requirements for those gap filler style pills. And as such, she ordered the pill to be rescinded. So there's a few takeaways from this case. First, it is pretty clear that pills cannot be used as a general deterrent against activist stockholders. But there is an open question whether they can be used as gap fillers in causing stockholders to more quickly disclose their positions to the company. Second, even when used in response to a threat to the corporate enterprise, you'd be well advised to adopt a pill with terms that are much more moderate than those found in this case. And third, and perhaps most importantly, this underlies the importance to keep pills on the shelf until a definitive threat materializes. All right, John, shifting gears a little bit, one feature we've seen included in more and more deals signed during the pandemic is an earnout provision. And there was a really interesting case recently that dealt with post-closing earnout covenants.
That's right, Brian. The SRS v. Albertsons case is the most recent proof of concept for the old adage that an M&A earnout is not, in fact, a deferral of purchase price, but rather a deferral of a fight. In 2017, Albertsons acquired an online meal kit provider called Plated. $175 million in cash was paid at closing, with the selling Plated stockholders entitled to receive up to $125 million in additional consideration based on the achievement of revenue-based earnout targets for the 3-year period following closing. After the earnout targets were not achieved, Plated's former stockholders filed a lawsuit alleging that Albertsons had breached the purchase agreement in executing what the plaintiffs called a hidden agenda to divert sales from Plated's online platform to Albertsons' brick and mortar operations. Albertsons filed a motion to dismiss, relying heavily on the earnout language contained in the purchase agreement. The covenant, shown in full on the next slide here, prohibited Albertsons from taking any action with the intent of decreasing or avoiding the earnout, but otherwise reserved to Albertsons remarkably broad discretion in the operation of Plated's business during the earnout period. Vice Chancellor Slights denied the motion to dismiss, finding enough in plaintiff's allegations to support a reasonable inference that Albertsons had breached the earnout target. Among the pleadings cited by the Vice Chancellor were allegations that Albertsons had represented in negotiations that Plated would be entitled to be operated independently post-closing, that Albertsons would support Plated's efforts to increase market share in the online meal kit segment and would gradually phase in its bricks and mortar strategy for Plated. The opinion quoted the following statement from the Albertsons management team made during the negotiations. Plated could easily achieve the projections for the next 3 years. Based on these pleadings, the court concluded that a trier of fact could reasonably conclude that Albertsons knew at the time that pivoting to a bricks and mortar strategy would cause the earnout milestones to be missed, and that its actions could have been motivated, at least in part, by a desire to avoid the earnout. So on to trial for this one, and another cautionary tale for those deal parties about to embark on using an earnout to bridge a valuation gap. Amelia, over to you for a very quick look at alternative entity case law developments.
Thanks, John. So it was a little bit of a slow 6 months in terms of exciting alt entity case law. One case to note, just as kind of a reminder of things to keep in mind if you're dealing with LLCs. We had at the end of June the Largo Legacy versus Evan Charles case. This case involved a special purpose vehicle LLC that owned a DoubleTree hotel, and there was an adjacent lot that it also owned next to it. The controller here, we had our SPV who was managed by an entity, and then there was a controller individual up the chain. That controller devised a scheme that involved transferring that vacant lot to an entity that he controlled for no consideration. He then siphoned off funds from our SPV LLC to develop that vacant lot and didn't reimburse the SPV LLC. So obviously the members of our SPV were very upset. They brought suit. First, they claimed that the manager had breached fiduciary duties. The court started by looking at our LLC agreement here, found that it did not disclaim fiduciary duties, and therefore our traditional corporate duties applied. So just as a reminder, with LLCs, LLCs, unlike corporations, can waive, modify, and even eliminate fiduciary duties completely in their LLC agreement. To the extent that an LLC agreement is silent with respect to fiduciary duties, our traditional duties of loyalty and care do apply. So here we had traditional corporate fiduciary duties. Then under our USA Cafes analysis, the court found that the duty of loyalty extended to our individual actor who controlled the managing entity. So under USA Cafes, if we have an entity that's managed by another entity, the court will break through those entities and go all the way up until it gets to an actual individual, and it can hold that person responsible for the breach of the duty of loyalty. Here, our defendant argued that there should not be a breach of fiduciary duties because all of the actions that he took were allowed under the LLC agreement because he had received the requisite member consent to do everything he did. The court rejected this view and found that just because something might be allowed contractually, it doesn't mean that fiduciary duties don't apply because they are there to protect our minority members. As the court said, inequitable action does not become permissible simply because it's legally possible. So whenever we're going to take an action with respect to an LLC, we need to look first to the LLC agreement to see how it can be done. And we also always need to bear in mind that fiduciary duties are at play. So with that, I will turn to Brian quickly for an antitrust update.
Great, thanks, Amelia. Yes, before we close for the day, we have moved outside of Delaware for one very quick and very important update for you on the antitrust front. So on August 3rd, the FTC announced that it would start sending what are being referred to as close at your peril letters in response to some HSR pre-merger notifications. They explained that the volume of notifications is so great that they are increasingly unable to complete their review in the allotted 30-day window. And so they are letting parties know in the event that their submission has not been fully vetted, that they are free to close, but that the FTC's investigation remains open and that they are closing at their own risk. So this comes on the heels of President Biden's executive order on July 9th, which called on the DOJ and FTC to revisit their merger guidelines and increase their focus on consolidations in healthcare, technology, and banking areas in particular. Along with this, he also reminded them that the DOJ and FTC are free to challenge mergers that previous administrations did not. So all this is to say there's a lot of movement underway in the antitrust realm, and we'll continue to monitor the developments here. We've included a couple of quick hitter cases that we're not going to discuss today in your materials, but commend to you to take a look at as they involve important practice pointers for those practicing M&A transactions. And with that, I'd like to thank Amelia and John for their time today, and we look forward to seeing you at the next M&A update in January.